Good afternoon. My name is Ann Bittinger. I'm the owner of the Bittinger Law Firm. Thank you for joining us for our October webinar entitled, Uh-oh, we have 3 doctors retiring soon, How Physician Groups Create Baby Boomer Physician Succession Plans and Keep Their All-Star Physicians from Jumping Ship. This is the latest in our monthly Uh-oh sessions, in which we provide education on subjects that we get calls about on a frequent basis. We try to address issues that are relevant to what we are doing here at the practice. We would find that clients would give us a call and say, uh-oh, we're having these problems. We came up with the name for the Uh-oh series because we would find that clients, often physicians or company CEOs or practice administrators, would call us and say, uh-oh, we're having a big problem. Got a few minutes to discuss it? And then as we saw trends, we developed the Uh-oh series webinars. I have muted all of your lines, and my contact information will be available on the last slide if you have any questions or anything to share. So with that, let's get started. We are dealing a lot with issues of succession planning in physician practices. Believe it or not, even though we are in a post-integration time frame in 2016, there are still quite a few independent physician practices that are owned by physicians. They are facing some great challenges right now in not only how to survive as independent practices that are not affiliated with a hospital, but how to have the internal ownership, leadership, and financial structures necessary to continue their practice through the next decade amid substantial change. Let's take a look at some of these physician retirement statistics. A healthcare economist is quoted as saying, there's much more rapid retirement of physicians. And what does this retirement mean? This will mean at least 100,000 fewer doctors in the workplace in 2020. Nearly 40% of doctors practicing currently are age 55 or older. Generally speaking, they likely will retire within the next 5 to 10 years, according to the Center for Workforce Studies of the Association of American Medical Colleges. Indeed, 12.1% of physician practice owners plan to retire in the next 5 years, according to Becker's Spine Review. 12.1%. Those are huge numbers if you think about the needs and transition of different practices across the United States. The Physicians Foundation has reported that in the next 1 to 3 years, over 50% of physicians plan to cut back on patients, to work part-time, switch to concierge medicine, or retire or take steps that would reduce patient access to their services. So that 50% is a huge number. It includes different types of ways of practicing other than retiring and not practicing at all. But it just shows the great need and the great emphasis on practices right now to make sure that they have succession planning in place. The key issue that I find here at my law firm in advising clients on how to transition and how to implement effective succession planning is that of expectation. So what we do when we go over succession planning with a client, whether we're implementing it for a new practice or whether we're taking a look now at a very successful practice to make sure that the documents that they had in place still fit their group, it is more or less almost a therapy session. We talk about what people's expectations are, what they expect to get out of the practice. So those issues can actually conflict sometimes depending on who we're talking to. We ask, what does the departing physician or shareholder expect to get out of the practice? So when that founding physician, whose name is on the nameplate above the door to the practice, retires, what is his or her expectation financially, legacy-wise? What does he or she expect to get out of the practice? Contrast that with what the remaining physician shareholders expect to have to give to that physician. And do those expectations differ if the physician who is leaving was not a founder, but simply was one of the shareholders there for quite some time? Contrast those questions to the question of, what do your staff members expect in terms of leadership change? You'll see a theme throughout my talk that just as important as the financial and legal issues are leadership changes. We have three main issues that we look at when we advise clients in these issues: leadership, legal issues, and then financial issues. And a good law firm will help you put in place a plan that addresses all three of those issues. Finally, what do patients expect in terms of short-term and long-term services? If your key physician leaves, what kind of drain is that going to put on the practice in terms of the availability of patients to get in to see physicians? How are you planning long-term, simply just to keep up the existing patient load once physicians leave? So you can see we start with a sit-down session and some interviews and discussions about what the different key constituencies expectations are. Then we take a look at what documents they have in place, and we do a little diagnosis of our own. Often what we see is that the expectations are not really provided for in the company's governing documents. So what governing documents should be in place to control the exit from the practice? All of these issues are something that really need to be more than just a handshake or a, well, this is how we've always done it, it's got to be fine, sort of a situation. A good physician group will have in place a shareholders agreement, which is often called a buy-sell agreement. Sometimes those two things are split out, but typically they mean the same thing. The shareholders agreement and the employment agreement for the shareholder physicians are two separate and distinct things. It was, I guess it's kind of an old school thing to put the employment provisions within the shareholders agreement, but the way we approach this now, for the most part, is that we acknowledge as lawyers that physician shareholders of a practice wear two separate hats. They wear an ownership hat in their role of owners of a company. They also wear an employment hat, meaning they provide services to the company just like any other employee. So we usually separate the rights and duties and obligations according to the different hats. The shareholder agreement will talk about what happens to buy out the physician from the practice. That's really what our talk is about today. However, the employment agreement is extremely important because what we're talking about here is what happens when the physician no longer wants to work, the physician wants to retire, and how does that impact his ownership or her ownership in the practice. So these things all must fit together. Sometimes we'll see ancillary agreements such as a deferred compensation agreement or an accounts receivable payment agreement, just different ways to get cash out of the company and into the hands of the physician who's leaving. Again, all of these contracts must have provisions that work together. So if a physician provides written notice of termination of his employment agreement because he no longer wants to work, is there a trigger in the shareholders agreement that says that upon his last day of work, the company has to buy back his shares? That's just one example of how all of these things must fit together. Within the employment agreement, how can we tailor these documents to fit the specific needs of your practice and to preserve founding physicians' investments? We can do this both in the employment agreement and in the shareholders agreement. In terms of legal services, what a good law firm will do is advise you on all of the different options, all of the different menu items, so to speak, that you could put into your employment agreement to fit your specific needs. For example, if you had one founding physician the buyout provisions 20 years down the road, once that practice developed into 20 physicians, might be different than if the practice was founded by a team of 5 equal physicians. So these are the kind of questions and facts that we have to look at in order to make sure that we have a fair buyout situation. Within the employment agreement, the key issue is how are the financials structured. Generally speaking, physician groups pay out just about all their cash to their physician employees and physician shareholders on a very regular basis. Physician groups, unlike other companies, generally don't keep a lot of cash on hand. A lot of that is, of course, to maintain the lifestyles of the physician owners by paying them salary and dividends. But also there's a smart asset protection component to that. You know, the more cash that the company has on hand, the bigger the coffer that's available to a potential plaintiff. So generally speaking, most physician practices are set up so that everything is paid out to physician owners on a fairly regular basis with a few months of overhead kept, that sort of a thing. So if it's basically based on accounts receivable, or if physician compensation is on an eat what you kill model, generally speaking, there's a little bit retained and everything is paid out to the physicians. Now, expectations of what you should get when you leave a practice that has been historically paying all of their money out and not, you know, building cash and investments within the practice is interesting. If there's really little cash, and the equipment within the company is really nothing more than beds and some equipment and electric, if the assets in the company are little more than beds, equipment, electronic medical records, and then intangibles, what you would expect to get and the value of your shares in that practice would be very little relative to, for example, a company that owns a factory that would have tons of assets and equipment, and that might keep a lot of cash on hand for investment internally. So what we do is we look at that. If that's the case, our buyout might be structured differently than if, for example, there's one shareholder and most of the physicians are simply employees getting flat salaries. So we explore that. In terms of transition planning, one tool that we as attorneys have is that of tail insurance and retirement coverage. One of my main goals is to make sure when I'm in this process that my clients don't go broke when their senior physicians leave due to buyout and other expenses. A big expense that can happen to a practice when a physician leaves is the expense of purchasing tail coverage. That being said, most medical malpractice insurance carriers will provide free tail coverage to physicians who, when they retire completely, and I stress completely, from the practice of medicine, if they've been covered for a certain period, which I usually see as 5 or 7 years. So one of the things we advise our clients as we're doing a check on retirement planning is, does your insurance company cover tail when people retire, and what are the provisions there? And then that becomes operational when the physician does retire. Is that physician then bound by contract to no longer retire, or excuse me, to no longer practice? And does the employment agreement say that if you do continue to practice in any way, you are responsible for your own insurance? Very important, that whole, are you retiring completely or not? As many of you know, sometimes physicians who retire get bored on the golf course and on the boat very quickly and want to do something back in the practice in some way. So it's an important provision to keep in mind. Non-competes and clean sweeps. What does the non-compete say about the physician retiring? Can he go and practice somewhere else? Very, very similar issues. So does the physician really retire when he leaves the practice, and what is he doing? And then again, as I said previously, there has to be a trigger between ending your employment agreement by retiring and selling your stock back. we'll talk in a few minutes about complex physician practice structures in which there are separate companies that own real estate. So we have to connect the dots also between the shares that the physician owner would have in real estate companies. Next, we look at the shareholders or buy-sell agreement. And the key here really is to make sure that the purchase price is defined in a way that matches the expectations of the group in a realistic way. So the purchase price is simply the amount that the practice pays the departing shareholder for his or her stock in the practice. Generally speaking, what we do is require the company to buy back the shares, although for a number of reasons, many practices like to require the remaining shareholders to purchase the departing shareholder shares on a per capita basis. So if there are 8 shareholders and 1 leaves, then each of the remaining buy 1/7 of the departing shareholder's shares. Lots of different reasons as to why you might do one or the other. But really what I'd like to focus on today is how important that purchase price for the shares is. The payout should be tied to the concept of whether there's a lot of cash in the company. Probably what I see most often is that the purchase price for the shares is based on the hard assets or fixed assets of the company, so the otoscopes, the stethoscopes, the EMRs, the computer, the beds, that sort of thing, the exam tables, and the value of the hard assets. A variation might be that it may or may not include accounts receivable as an asset of the company. We need to specifically say whether intangibles like accounts receivable or goodwill are included. I rarely in 2016 see goodwill as specifically something that's represented in the purchase price or that's valued in order to determine the purchase price. It's just very difficult to put a dollar amount on goodwill, and so that structuring it with a value on goodwill simply just invites litigation about the purchase price. So generally speaking, if the practice is an eat what you kill practice where they're paying out the revenue to the docs almost completely, we usually set the purchase price at a value representing the hard assets of the practice. If the physician had an expectation, again, getting back to my expectation, that he gets a certain percentage of all of his accounts receivable, for example, if he's been on an eat what you kill model for many years, as you know, in physician practices, it takes about 60 to 90 days to collect after a service has been performed. So the physician might have an expectation of a certain percentage of accounts receivable. We might account for that either within the buy-sell agreement or perhaps in a separate accounts receivable agreement. And we might change the percentage that the physician usually gets maybe to something lower, but somehow put some value onto the accounts receivable to pay that out to the physician. Now, the perfect storm often happens. As you know, when a practice is started by some entrepreneurial physicians, a lot of times if there's a group of founders, they're pretty much of the same age, right? Sometimes you'll have a senior and a younger physician found, but pretty much you might have, physicians of the same age. So what happens if they are wildly successful, they work for 20 years, and then sure enough, all of them reach 60, 65, about the same time, and they want to retire? One of the tools we have as attorneys to protect our clients, meaning to protect our physician practice clients, is to include provisions where the payout would differ in the event that many physicians retire at once. So let's say that an amount was to be paid for the purchase price over the course of 2 or 3 years. What we might do is include a provision that says that payment is extended to 5 years if 5 or whatever number is appropriate to the practice, physicians retire in a rolling 3-year time frame. So it's important to kind of have a rolling calendar, a rolling period of time that is kind of a snapshot right when the physicians would retire. So as lawyers, we can sometimes be in a little bit of a sticky situation here from an ethics standpoint. If our client is really the physician practice rather than the individual shareholders, and we get calls from the different physician owners who we're used to dealing with all the time because they're the owners, and they say, you know, I'm thinking about retiring, and you knew that another one was going to retire, it's an interesting check on our ethics to say, you know, Dr. Smith, you know, you might, I'm counsel for the group, not your counsel, and I don't mean to be rude when I'm saying this, but my allegiance is to the group, and so let me tell you about my friend who also does this sort of work who could probably represent you on your departure. Because there can be conflicts between, of course, the physician and the group, particularly if there are a number of physicians who are retiring about the same time, if this sort of payout differential provision isn't included. One of the things that we also do in order to protect the practice from being cash-strapped is to require a really long notice period prior to retirement. So, you know, the notice period for most physician employment agreements for without cause termination is anywhere between 30 and 90 days. If what we're talking about here is outright employment termination by retirement, we might ask for 120 or 180 days notice so that the practice has time to plan. This is important not just from a financial payout of the purchase price situation, but also from a recruitment of a new physician standpoint and patient care issues. So sometimes we might add either in the employment agreement, the EA, or the shareholders agreement, the SHA, that we require a longer period if the reason for termination without cause is to fully retire from the practice and to therefore leave as owner of the company. One key that also helps in many aspects, not just the financial and legal aspects, but some of the leadership and cultural change issues, is to include slowdown options. So is there an ability, is there an existing structure to allow a physician to go part-time, to do some consulting and that sort of thing? Sometimes it can be very, very valuable to already have those sorts of frameworks in place in the event that a physician would elect them. And let me tell you why. Sometimes the slowdown is put in place or is caused due to the physician's health or other issues that might fall under the Americans with Disabilities Act, or maybe even the Family and Medical Leave Act if a spouse is perhaps going through a health problem. Failure to have adequate contractual provisions that govern that sort of a situation can lead to exposure under the Americans with Disabilities Act and with the Family and Medical Leave Act. So there are ways to do this properly and not just kind of be nice and let the physician do whatever he wants, and then you have kind of a mess on your hands. So having some set pathways for physicians to go down before they actually cut the cord and retire completely can be helpful. But again, look at the big picture and make sure that the employment agreement and policies and procedures and FMLA and ADA are being met. Key person insurance or key man insurance is also very important. Very, very important. Most smaller physician groups definitely should have key man insurance. What that is insurance that pays typically in the event that a shareholder dies. It's basically kind of a life insurance benefit in a way. What we might do with key man insurance, and sometimes you can get insurance to cover all sorts of different kinds of things, not just, you know, a life insurance type of departure upon death or retirement from the practice and share buyback upon death. You could do it in lots of different ways. But what we sometimes do is that if the reason for the buyback of shares is death rather than simple retirement, we would put the purchase price and define the purchase price and say that it is the value of that life insurance or key man insurance policy versus the hard assets of the company. So the provision might read something like this. In the event of a retirement from the practice, the purchase price shall be determined based on a CPA's assessment of the valuation of the hard assets of the practice, provided, however, that if the reason for the buyback is instead the shareholder's death, then the definition of purchase price is the value of the insurance that the company has on that person's life. Or you could just go ahead and state the value, $1.5 million. So there might be a little bit more of a windfall, which can have some tax and financial benefits to the estate to define the purchase price of the shares that way. Lots of issues go along with that. That was very much a very nutshell approach to key man insurance and the tax implications, but that is also always an option. And then finally, if we have an issue of expectations where the physicians who invested their entire careers in this company want to leave, and they want more out of it than just, their share of the hard assets of the company, we might place financial expectations in an entity other than the operating entity, for example, real estate. So perhaps the buyout from the physician LLC entity that owns the real estate might be bigger than the physician practice. Let's turn now to how practice culture and generational issues impact transition planning. I've been doing this kind of work since 1998, and it's been interesting to watch the different sort of cultural or generational stereotypes that seem to be more than stereotypes at times come through in this sort of succession planning. One goal that every physician group needs to have now in 2016 is to make sure that the younger doctors don't jump ship. So buying out the main founding shareholder for a huge amount could have a decimating impact on the younger shareholders' desire to stay in the practice. So we have to balance sort of Gen Xers versus baby boomers versus some of the early millennials. What we're seeing now is, so much of a focus on the younger folks on work-life balance. And statistics show that the Gen Xers and those who are now currently in their 40s and younger are placing a greater emphasis on lifestyle, on work hours, and quality of life than their predecessors have. That component and the financial ramifications of that component of the physician population is very interesting and challenging when it comes to trying to finance the exit of the baby boomer doctors who were founders. So historically, throughout the late 90s and early 2000s, the way we would handle this is you just had to have really, really productive younger physicians in order to make enough money to finance the buyout of the older doctors. That is not necessarily something that's possible right now. So what we're doing is looking at outside-the-box approaches. So greater implementation of extenders of nurse practitioners and physician assistants is sort of impacting the big financial and legal picture here. Another issue is requiring the younger physicians to maintain a certain level of productivity or they're terminated. So if you're sort of a top-heavy, meaning older, established physician group that has a number of older physicians, one of the things that they're seeing that they need in order to maintain the practice revenue as the older physicians start to wind down their careers is the need to implement some sort of minimum level of productivity or collections by the younger doctors. The whole eat what you kill concept that used to work for decades to finance departures doesn't necessarily work, because what we're seeing is that the younger physicians are content with working less and making less than somebody who would be working, crazy hours every week, but then there's sort of a counter issue where it seems like they want all of what they make. You know, their attitude is, generally speaking, less of a teamwork attitude and less of a I'm going to pay my dues just like everybody else did before me situation. They want to work less and keep more of the money than people have in the past. So it creates a very, very interesting dynamic. And I think what's important, I think one of the more important things that I do with clients is to just make them realize that this is what's happening, and to look at the financials and physician individual productivity, not in terms of necessarily the bottom line, but what that means bottom line 10 years out when the baby boomer physicians are retiring. So to kind of look at this big picture and see what's going on and looking at how they'll finance their departure. In summary, as I mentioned earlier, transition planning is really a strategic investment in your practice. It is akin to implementing a new electronic medical record system, to implementing a new payment system, to building a new building. I mean, the practices that are physician-owned really need to make this investment in transition planning in order to make sure that the practice survives. Financial, legal, and leadership issues all are very, very important. Without emphasis on the leadership component, the financial and legal issues won't work. Without proper legal work, the leadership will not have the proper structure in order to be successful. So how do we incorporate knowledge from existing employees and outside advisors in the process? My words, be humble. I've been representing physicians and physician groups for just about 20 years now, and so I smile here on my end of this call as I think about telling physicians to be humble. But really being good listeners and listening to advisors in this process is key. There are so many tax issues involved in all of this that having a CPA at the table throughout it all is just essential. Having an attorney who is happy to guide you through to identify issues that are unique to your practice and to find a fit for that specific issue is key. A 50-page boilerplate buy-sell agreement in your inbox is not really doing you a good service. I also really like to use the opportunity when I have a group that says, okay, we really need to get our ducks in a row on this. We threw together our practice 10 years ago, and now we're facing these issues, and what do we do? I really like it if the practice is, I guess, creative enough to bring in some coaching to really deal with the leadership issues that are so important here. There are lots of companies out there that do physician practice advising in terms of leadership roles, coaching, leadership development, that sort of thing. So I like to use this legal window as a way to put in place some of the leadership issues that need to come out. And it's really important to trust non-physician executives through this process and to listen to them. Some of the most creatively stimulating work and work that I say, boy, we really did a good job on that in this area that I see comes from when CEOs or practice administrators are in-depth involved in this process. First of all, they are the best at telling the politics of the situation and saying, yeah, that might work, but this component of the physician population is not going to let that fly. And then also knowing how all of this works in terms of the overall practice. Having executives at the table going through this process is key. So let's turn now to addressing practice real estate asset ownership when the physicians depart. As I said, most developed physician groups are not just renting their office space. They have purchased land, they've purchased buildings, they've built buildings, and when they've done that for asset protection and liability purposes, that's usually been done through a separate LLC or LLP, right? sometimes a corporation, but generally a limited liability entity. So those are separate corporations, and the physicians that invested in them got shares not only in the physician practice, but also in this real estate entity. And then as the practice developed, newer, younger physicians, when they were offered partnership, were given opportunities to buy in or to simply get shares in the physician practice as well as the real estate entities. That's not always the case. Sometimes the ownership of the physician practice is not a mirror image of the ownership of the real estate entity, but definitely a trigger of termination of employment for retirement has some impact on whether their ownership in the real estate company should remain. So real estate is a little bit different than a physician practice. So real estate is a real estate asset. It's land, it's building. It's not a services company like a physician group. So there's some real value within these entities. However, it's not a liquid asset. When a physician leaves, they don't just sell the property and divvy up the assets. So we look at focusing on what should the, quote, purchase price be here. Typically, it's very, very different than what it was from the purchase price of the practice. We look at buy-in amount versus buyout. So if, in order to buy in, the physician had to, pay $50,000 or $100,000 for her shares in the real estate entity, should she have an expectation of her money back? She's probably had no return on her investment throughout that time frame, right? Because it's not like, there are dividends that are generally paid out. Usually the physician practice pays rent and deducts that rent, but pays it to itself rather than pay it to somebody else, so to speak, pays it to their shareholders or to the company owned by shareholders. So it's really kind of a fluid situation. But what if it's a big building that has 5 floors and the practice only takes up the first 2 floors and they get rent from the upper buildings? Should that make a difference? Or excuse me, they get rent from the upper floors. Should that make a difference? A good lawyer will explore all of these things with you in terms of writing the definition of the purchase price. On rare occasions, clients want to allow physicians to remain owners of the real estate entities even though they're no longer working for the group. That is rare. Typically, it's if maybe there are just a few owners of the real estate group and they're looking, long-term to sell the property, or it's kind of a long-term asset for them. But sometimes that happens. In those sort of situations, my question to clients is, well, this is your space. Do you really want someone who no longer works for you to be around the table voting as a shareholder of the company that owns the real estate assets? Generally speaking, there aren't a whole lot of decisions to be made, though, on the other hand. And the shareholders agreement can be structured such that maybe one manager of the LLC is the one who really makes all the decisions about the real estate, so that retired guy really has not a whole lot of say about what goes on. These are the kinds of questions that we ask when we try to work on the buyout of the real estate entities. So let me turn now to the softer side of this, the leadership, development, and transition. It takes more than just money to continue the practice. Even with good financial footing, a practice will fail without good leaders. So what kind of leadership development program has been in place? What kind of leadership development can we put in place? What's the hierarchy of decision making? What kind of committees does the group have to vet the leadership abilities of the physicians and to see who's next in line for leadership? How do we use non-physician executive staff to develop the leadership? Are we setting up a team not only within the physicians for leadership, but within our employees for succession planning? That can be key. If you want to see a practice that is really having a hard time, it's when its senior physicians leave and the younger physicians decide they want to bring in their own new executive. there's just a lack of institutional history at that point in time where you see some practices struggle. So using leadership development in executive non-physician staff settings is very important. Use of counsel and CPA, very, very important in terms of leadership development. Often physician groups have different presidents or leaders every few years. And so your institutional knowledge comes not from your physician leaders, but from your outside counsel and your CPA. Very, very important. And I'd like to close this slide with the concept of legacy. One of the things that I hear from my founding physician clients or the founding physicians within my group clients is that they really want to have a legacy to their practice. They really want what they built to continue, whether it has their name played on the door anymore or not. There's this sort of vested emotion to want to see this thing survive. And I think that using that concept and that emotion in a way that continues through the transition and the leadership is key, and utilizing that issue in how to sort of work out the bumps in this process in terms of the politics and the I want this, but I want this. If we can say, well, what about the legacy? That tends to sort of bring everybody's focus in line about the big picture. So with that, I thank you today. I hope that this was a meaningful overview of how physician groups transition their practice when baby boomers retire and the young ones come in. If you have any questions, feel free to email or call. And with this, we will sign off. Have a great day.